Hello, dear students. In today's discussion, we will talk about judicial review in brief, the basic introduction of judicial review. See, we all know that a state has a three organ, legislature, executive, and judiciary. And all these three organs has a role to play when it comes to legislation. See, the legislature is there to make the law, and executive, the another organ of the state, is to implement the law. But the law which is made by the legislature and being implemented by the executive need to be according to the constitution. If it is according to the constitution, in that case, it is valid. Otherwise, it is invalid. But now, who will examine, who will say whether the law is according to the constitution or not? So the task has been assigned to the constitutional expert organ of the state, and that is judiciary. So it is judiciary, the third organ of the state, जो आंख जैसा काम करता है, and it reviews whether the law made by the legislation is according to the constitution or not. ठीक है? So this entire process of reviewing the constitutionality of the law is called judicial review. Article number 13 of Indian Constitution talks about judicial review, but to be mentioned, the term judicial review is not mentioned in article number 13. Article 13 explains this entire concept very implicitly. That means it do not mention about judicial review, the term judicial review, and it is not very straightforward. In a very implied manner, it explains the concept of judicial review. The concept of judicial review is taken from USA. There, it developed in a case called Marbury versus Madison. In India, the power of judicial review lies with Supreme Court and High Court, and judicial review is not the suo motu power of the Indian court. That means they cannot pick up any case or any law by itself and test its examine its constitutionality, but they can do it only when the petition has been filed for such matter before the court of law. Thank you.